Let's see.
I gotta take my car to
What is this? I have never in my life.
Well, that's the largest we've had in a long time.
Mm-hmm. Hey, Brad Cross, can you hear me?
Yeah.
Mickey Shelton's not going to be on the docket, so you can be released.
Thank you very much, Jason.
Thank you. May need you next month.
Yes, sir. Have a good day, and thank you.
You too. Thank you.
Okay, let's come to order, please. We have private attorneys on here. Mr. Carroll, I see you on here. Who's your?
I have Matthew Denny, Joseph Craig, and Eddie Bowman.
Okay, are any of those? Go ahead, Mr. Stockton.
I was just gonna say Eddie Bowman's not on the docket.
Okay.
Yeah.
We had him for tonight.
All right. We'll mark him off then.
And Mr. Craig, I don't believe is in custody, so.
He is not.
You have him with you there?
He is out on my front porch, Judge.
Okay.
We can go get him.
Well,
And Mr. Denny
where is Matthew Denny located?
He's in jail.
Russell County, there's 3, we deal with a lot of jails.
I have no idea, Judge.
He's in Clayton County, Judge.
Clinton County, okay. Russell County, if you'll turn your camera off, we'll come right back. Okay, we'll need in the Clinton County Jail, we'll need Matthew Denny, please.
I'm gonna have Jeff Vincent for him.
Amber.
They're probably down at the grand jury.
Maybe you can tell Eddie Bowman to go home.
Well, I am, but I was looking on here, Tom, and I had done the renotice and sent it out with the others to move it to today. I don't know why I didn't get, because I did it with, we moved Joseph and then, so I'm gonna go ahead.
Your microphone's on, Mr. Carroll.
Okay, sorry about that, Judge.
Mr. Stockton's taking notes real.
That's all right. We were just discussing Mr. Bowman.
We know what.
Go home.
We know what you were discussing.
Yeah, because you listened to what I was on. Very good. I'm a little slow this morning.
Whoever has the clerk's office camera on in the courtroom needs to turn that off if they're not involved in this Denny case.
Judge, you want me to go ahead and get Mr. Craig while we're waiting on them to bring Mr. Denny to the camera?
It won't take long.
Okay.
I'm here. Who in the clerk's office is operating the camera there? Okay, thank you. You want to flip the camera off in the clerk's office?
Hey, Judge, David Cross is in here today.
Well, when we call his case,
Okay.
we'll turn it back on.
Okay.
This doesn't make for a good record to have all these different things on there, you know? Do you have a plea? Are you going to have a plea on Mr. Craig?
No, Judge, I mean, we don't have
Okay, I was just asking. I don't need to know
yeah,
anymore.
we don't have a deal worked out.
Okay. Let's go ahead and take him.
All right, I'll get him. Bring Craig on in.
And Judge, he has a pretrial conference in one case, 2 motions to revoke bond, and an arraignment.
Okay. Mr. Stockton, we're going to go ahead and go with Mr. Craig.
Okay. You shut that door in Amber's office.
Put that behind you.
I meant to, and I forgot to.
Stand right back here behind me. Judge, Mr. Craig is,
Okay, tilt your camera up a little bit. Okay, this is Commonwealth of Kentucky versus Joseph Edward Craig, 20 CR 0073 for a pretrial conference. And also we have an arraignment. So I'll go ahead and do the arraignment first. 20 CR 0041. Is your name Joseph Edward Craig?
Yes, sir.
You born in 1975?
Yes.
The last 4 digits of your social security number, 5994.
Yes.
The grand jury of Clinton County has returned an indictment charging you with engaging in organized crime, drug paraphernalia possession by or sale, possession of marijuana, complicity to trafficking in the first degree, first offense, complicity to trafficking in controlled substance, first degree, first offense, complicity, trafficking in first offense, trafficking controlled substance, first offense, and complicity, trafficking controlled substance, second degree, first offense, complicity, second degree, first offense, complicity to OBS, trafficking controlled substance, third degree, first offense, and complicity, OBS, trafficking controlled substance, third degree, first offense. You understand those charges?
Yeah.
Yeah. Okay. You acknowledge your identity?
Yes.
Mr. Let's see here. We got this other case too. Counselor, do you acknowledge the identity of your client?
I do, Your Honor, enter a plea of not guilty.
Waive formal reading and arraignment, enter plea not guilty, and reserve all pretrial motions. Is that right, Mr. Carroll?
That is correct, Your Honor.
Okay, well, I will let him continue on the same bond that he's out on for these cases. And we'll switch over to 20 CR 0037. And we also have 20 CR 0077, which is a motion to revoke bond, which I failed to call a few seconds ago. Mr. Stockton, what is your pleasure on the 2 other cases we have?
Your Honor, I'm asking that Your Honor, I'm asking that Mr. Craig's bond be revoked on those cases, basically because he's been charged with and subsequently indicted on new trafficking charges. He was in the presence of Jennifer Stockton, him and his wife, when numerous drugs were found on her person. And this is the second time, I think, according to the sheriff, this has happened. I've got him prepared to testify in this case.
Judge, as I understand the facts, they followed.
You want to flip over to your face shot, move the camera around.
All right. Judge, they followed.
Who's they?
The police followed this lady who is Mr. Craig's sister-in-law into his trailer. They had a search warrant that said she would have all this stuff with her. She walks into his trailer. They walk in behind him. All this stuff was found on her person, in her purse or her bra.
Well, I take it that you're not stipulating.
I am not stipulating. No,
Okay,
Judge.
then we'll need to take some evidence. There's no reason to hear it twice. You gonna bring your witness, Mr. Stockton?
Yeah, I'm looking for him on here and see if I can find him. Amber, have you got your computer on? I tell you, Judge, what we did was going to have the sheriff testify from a different computer in our office, but we're having technical difficulties. If we can wait a few minutes, maybe call another case, I'll just send Sheriff Vincent to the courtroom because he's got this case and the motion to revoke bond on Matt Denny, both.
Just call up there now and send him.
He's in my office. I've just has to send him up to the courtroom. So he
Turn the camera around and camera
Okay.
ask questions. Okay.
Okay, I'll do it that way then.
Yeah.
There you go. So we can sit down.
Right here, sir.
Yes.
You can sit down. Okay.
Morning, Sheriff. Will you raise your right hand?
Good morning, Judge.
You swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Okay, Mr. Stockton, would you inquire?
Yes, Sheriff Vincent, have you recently had an occasion where you arrested Jennifer Stockton at the residence of Joseph Craig and Stephanie Craig?
Yes, sir, I have.
And was also Mr. Craig and Miss Craig charged?
Yes,
And that happened on March the 12th of this year?
that's correct.
Can you tell the court what happened?
Well, we had obtained a search warrant for that residence because information led us to believe that there was heavy drug trafficking going on there. We executed that search warrant. Miss Stockton was found to have, I think, about 2 to 3 ounces of methamphetamines on her person. She also had a number of drugs, some morphine, probably hydrocodones, marijuana. There were scales and baggies, and a lot of evidence of drug trafficking that we recovered there.
Let's break this into 2 categories. Did you find anything of evidence of drug trafficking other than on Miss Stockton's person?
Well,
Like the scales, the baggies and things like that?
they were inside the residence of Mr. Craig and Miss Craig.
Okay, you're talking about digital scales
Yes,
and baggies?
yes,
Are those items commonly used in drug trafficking?
yes, they are.
And where were they located in the house?
They were located on, I guess you'd call it the kitchen table, because it was actually a motorhome type residence that they were inside of.
Can you find that lab report in there on Jennifer Stockton's, this case? You said 2 to 3 ounces of meth. Now that was found on her person.
That is correct.
And where was it found on her person?
It was she had it inside her bra.
Okay. Were all the drugs that you found, were they located inside Miss Stockton's bra?
They were.
Okay. Now, when you went and executed the search warrant, had she been in the house for a while, or do you know how long she'd been in there?
I don't. She had a camper, a fifth wheel camper that was located on this property also. And then the Craig's residence was this motorhome type thing inside a barn or shed there.
Okay.
And at the time we executed this search warrant, she was inside the Craig's residence with them when this evidence was found.
Okay.
It was not in her camper. It was in the Craig's residence.
Okay. When you obtained the search warrant, you'd had evidence that there was a high volume of drug trafficking going on from that area.
I did, sir.
What kind of evidence did you have to support that?
Well, I'd had a confidential informant tell me that they had saw Miss Stockton dealing drugs there. Me and my sheriff's deputies had also been watching this place for a couple of 3 weeks, and there was a high amount of traffic in for a short period of time and out all during the night up through midnight, maybe 1 o'clock in the morning a lot of times. That was an independent surveillance that we did. A lot of these people we knew had past drug problems or drug convictions. And then the fact that the Craig's was located with Miss Stockton 6 weeks prior to this on another drug bust that we had got Miss Stockton on with another 2 or 3 ounces of meth on North 127, where her camper was located and she was residing at that time.
Okay, when you busted Miss Stockton 6 weeks prior, was that at another residence she was at?
It was at the camper that she had located at the intersection of North 127 and Wells's Bottom Road. And it was the fifth wheel camper that was moved after that drug bust to the Craig's resident at Locust Grove area.
Okay. Now the Wells Bottom address, that's a remote part of the county. Is that correct?
The Wells Bottom part is, but it was just right on, it joined 127 and Wells Bottom Road on the south end of Wells Bottom Road.
Okay. And when you busted Miss Stockton on that occasion, during Miss Craig inside the residence?
Mr. Craig was outside the residence. He had gone to a building to get a heater when I approached him, but Miss Craig was inside the camper with Miss Stockton at the time.
Okay. I have no further questions, Your Honor.
Mr. Carroll, would you like to inquire?
Yes, Sheriff, the information that your informant had given you was that Jennifer Stockton had this illegal substances on her and in her bra, wasn't it?
The one that gave me on this occasion was that Jennifer Stockton, that he had witnessed Jennifer Stockton do a drug sale at this property.
All right. Now, when we talk about this property, you've got at least two different residences on it, do you not? The camper and the motorhome.
Yes, sir. Yes, a camper and a motorhome. Yes, sir.
And so when you use the word premises, can you tell us which of those places he had seen your informant had seen a transaction take place?
This was the property at Locust Grove.
Okay,
off of Huntersville Road.
Did he specify whether it was the motorhome or the camping trailer?
He did not.
Okay. And he told you that she would have this in her bra, correct?
No, that was at the other location, I think. And I don't think that it was mentioned that it was in her bra. Just the fact that she had made some drug transaction.
Well, I'm reading from your affidavit for a search warrant. Informant said that Jennifer Stockton left the illegal drugs in her bra and drug paraphernalia was visible at this location. Now, are you saying that's the...
You're probably right, sir. I've not looked at it this morning.
And so the information you had was that Jennifer Stockton was the one that was doing illegal acts at this location.
That's correct.
And you don't know which of the two locations, as far as the residences are, that the informant said she would be at?
Did not say, no, sir.
And didn't you follow her in pretty closely, actually track her into that residence when you did the search? Weren't you just hot on her heels?
With this night?
Yes.
What do you mean? No, we had not been on the property until the search warrant was executed.
But didn't you follow her to that location?
Did I follow her to that location?
Yes.
No, I walked into that location and she was located inside this motorhome.
Okay.
Okay, well, hold on just a second, gentlemen. I'm confused about the motorhome. Her home, let's call it the Craig home or her home, and call her by name when you're talking about which one. That way we won't have some clarity, okay?
Okay.
So I guess which one would you walk into?
You walked into the Craig motorhome to execute your search warrant. Is that correct?
Walked in, came in from the north side. There's a church above that. Myself and Deputy McGuffin walked in through the woods. We came by the Jennifer Stockton camper. Didn't appear that there was anyone in there, and we proceeded on over to the Craig motorhome.
How far is that church from searched premises?
Just across the road.
Okay. So you all were sitting across the road at the church premises.
Your Honor, I'm going to object. This has been asked and answered. He said he didn't follow her in.
Well, let's move on. Let's go on, Mr. Carroll.
Let me ask you this. Did you see her go from some highway into the Craig premises?
No, sir.
Okay. And do you know how long she'd been there?
Don't have a clue.
Okay. And when you went in to execute the search warrant, where was Mr. Craig and Mrs. Craig?
They were in the bedroom area of the camper
Okay.
motorhome.
Did it appear that they had already gone to bed?
They were in the bed.
Okay.
Yes.
And where was Jennifer Stockton located?
She was sitting at the dining table.
Okay. So she was sitting at the dining table in which you found some scales,
Yes, sir.
and she had all of the drugs that you seized on her person.
That's correct.
And you expected to find them on her person because your informant had told you they would be on her person.
Yes, more than likely. Yes, sir.
And that informant, according to your search warrant, never mentioned Mr. Craig or Mrs. Craig, did it?
No, just said that she was selling at the Craig's residence or property, the property, I guess you would call it.
Okay. And that property included her own personal residence.
That's correct.
Okay. And while you were there, was anybody else on the premises?
There was some vehicles that came in and out while we were there.
Okay. Did you identify those, stop, talk to anybody?
We did.
Whom did you talk to?
Pardon me?
Whom did you talk to?
Bethany Canancer.
Objection,
was
it's
there one
irrelevant to
time.
this hearing.
Well, this is not, Mr. Carroll, this is not discovery here.
Okay.
Okay, let's stay on point here.
Now, did
I'm
you
sure they were glad to see the sheriff, but we'll move on.
did you search the entire Craig motorhome?
Pretty much, yes, sir.
Did you find anything else anywhere else?
Found a pill in the bedroom drawer. You know what? Ended up not identifying that or charging anybody with that.
Okay. And so the sum substance of everything you found was under the control of Jennifer Stockton.
Yes, sir.
All right. I believe that's all the questions I have, Judge.
Mr. Stockton, would you like to inquire?
Give me just 1 second, Your Honor. If you don't.
Okay.
I have no other questions.
Okay, the sheriff may go off camera then, and you can resume your.
Thank you, sir.
Hang around for due diligence a second.
Does he have another case he's involved in a minute?
Yes, we're also have a motion filed to revoke Matthew Denny's bond. The sheriff's a witness in that also.
Okay, we'll get to that next then. Okay. Okay, you have any other witnesses, Mr. Stockton?
No, Your Honor.
Okay, do you have any witnesses, Mr. Carroll?
Nothing further, Your Honor.
Okay, Mr. Stockton, I'll hear you on this.
Your Honor, I'm going to ask that Mr. Craig's bond be revoked. At the bare minimum, Mr. Craig had been present with Ms. Stockton on 2 different occasions when she had drugs and was trafficking
Is she a convicted felon?
She is, Your Honor. She's
Yeah.
multiple times convicted felon.
Okay, now is that a condition of his bond that he not be associate with convicted felons? I know it is probationers.
I don't know.
He's not on probation or parole, is he?
The condition of his bond was a 24-hour curfew subject to random drug and alcohol testing and all other standard conditions is the bond decision that I have.
Okay.
At a bare minimum, Mr. Craig was furnishing a place to traffic drugs. He has been charged with complicity based on the facts of this case. And he was on a bond already for stolen property at this same location. And I'm asking that his bond be revoked so he's bound over for trial.
Mr. Carroll?
Judge, the testimony of the sheriff clears him of any involvement in this activity that his.
You want to move the camera on you a little bit?
I can move over, Judge.
That'll be good.
The sheriff's testimony is that everything that was found was in the possession of Jennifer Stockton, and his affidavit for a search warrant established that she had it before she went into the trailer or the Craig motorhome.
I'm going to object to that line of reasoning. That testimony does not indicate that. It indicates that she had to know where it came from.
Well, it said that she had it in her possession, and the informant had seen it and knew it was in her bra. Doesn't mention Craig having any involvement in this whatsoever. Everything was found at the table that she was seated at with these folks and the other two defendants in bed. Judge, it would be unfair to revoke his bond on these conditions. And we have to keep in mind that he is presumed to be innocent until proven guilty. And it looks like the sheriff has pretty well proven him innocent. That's all I have.
Okay, Mr. Stockton, would you like to respond?
I would just say that the sheriff's testimony is ample, I think, to sustain a conviction for complicity, because there's not too many people running around here on bond that is providing a residence for someone to live at and another residence from the traffic drugs. That's not your usual activity you do when you're on bond for felony cases.
Well, I've heard the evidence, and I think there's some issues that we'll probably hear later on in the case. You know, there will be some issues. I don't have the benefit of having the search warrant in front of me, and the search warrant at this juncture has not been challenged. So that's not before me. But we're not talking about large houses here where people might be in and out without someone else knowing that they're in and out. These are small residences, and it sounds like to me from the sheriff's testimony, he's an experienced law enforcement officer, not only a sheriff of Clinton County, but with years of experience in narcotics work with the Kentucky State Police. Court will take notice, judicial notice of that. That people that he knew that were drug related were coming up and down to this location. She was inside with drugs and scales, and they were in the place there, and there have been some testimony. I mean, I just think there's more than ample proof. She is a convicted felon on these things. That there's more than ample proof that if she'd been there and not a bit, and Mr. Craig had not been aware of it, it'd have been a miracle. You know, that she would have been kind of like a ghost coming in and there. So I'm going to order him to turn himself in and revoke his bond on this situation. He should have been extra careful with whom he was associating, what kind of activity he was around, and what was going on. And this home being moved from another location where a drug buy had been and appearing right next to him, and her being in his house. I mean, all those things just line up. You might be able, Mr. Carroll, later on to attack certain aspects of this case, but that's enough. So I'm going to revoke his bond, tell him to immediately go to the Clinton County Jail and turn himself in.
Will do, Judge.
Okay, now on these other cases here that we have, you got 3 cases now. You got pre-trial. Are you going to elect which one of these cases to go forward with, Mr. Stockton, or do you want a month here to negotiate with Mr. Carroll on all of these to see if you can come to some resolution?
That'll be fine. If we can set them for a pre-trial next month, we'll either know if we can settle them or if we need a trial date on one of them.
Okay, well, Clinton County is on June the 10th, and hopefully by June the 10th, Mr. Carroll, Mr. Stockton and I have been waiting on an order for the Supreme Court to make it clear as to when we can go back into the courtroom, and we don't have that yet. So on June the 10th, you have your client will be there, and you negotiate in good faith with Mr. Stockton between now and then. Maybe we can accomplish something. Okay. And Mr. Craig, do you understand that you're to immediately go over and turn yourself in? Okay. You got any problem with that? You going to cooperate with that?
Yes.
Okay. Well, we could have the Wayne County Sheriff come in, but I don't want to put you through that or them through that. You just drive to Clinton County and the sheriff will have papers over there to get you admitted. Okay. Thank you for your cooperation.
Judge, I think you can rely on him.
Yeah, well, I am relying on him. He can rely on me too. If he doesn't come, it won't be a good thing. We both understand each other. We'll have it until we don't agree. What's your next client, Mr. Carroll?
Matthew Denny.
Okay, and now is the Clinton County Jail on yet here?
Yes, we're here, Your Honor.
Okay, and then when we finish this one, I'm going to switch over to Russell County. They've been very kind to hold on.
Judge, is it all right if he waits here a few more minutes so I can talk to him when we get finished?
Yeah, that'd be fine. Yeah. Commonwealth versus Matthew Denny.
I'll grab him. Oh, he's in jail. I'm
He's in
sorry.
jail. Yeah, I thought you did. Commonwealth Kentucky versus Matthew Denny, 20 CR 0047 and 20 CR 0076. Are you Matthew Denny?
Yes, sir.
Your year of birth is 1986. Is that correct?
Yeah. Yes, sir.
And last four digits of Social Security 7916. Is that right?
Yes, sir.
We're here on a pretrial conference on these charges. Looks like we have some receiving stolen property and parts from a vehicle, burglary, and another burglary charge. What do you have, Mr. Stockton? Y'all have an agreement in this case?
No, Your Honor, I have filed a motion to revoke Mr. Denny's bond in these two cases. I have two new cases that are going to the grand jury today on Mr. Denny that are thefts. I have filed a motion to revoke bond. I've attached the Kybers report in both cases. On April the 27th, 2021, he broke in and went into Steve Cooksey's shed. Mr. Cooksey lives about a half mile off the road. He's caught on camera doing that. Also on May the 1st, he went to the former residence of the late Nida Denny. In that case, that place had been robbed a couple of times before, and he was observed on camera in that residence. And we're asking that his bond be revoked.
Mr. Carroll?
Judge, we don't agree with, we're not going to stipulate to that. And further, I have a motion to suppress the evidence in the case that is being, wanting to revoke the bond on.
On both cases or one?
Talking about the new cases, Mr. Carroll?
The old case that they're wanting to revoke the bond on.
0047 and 0076. Which one of those cases?
The 20 case, Judge.
Both of them are 20 cases. They're two cases. 20. One of them has receiving stolen property, automobile parts, and burglary third. That is 0047, and then 0076 is just burglary in the third degree.
Both of those, Judge.
To suppress both of those.
Yes.
I don't have a motion to suppress in 20 CR 76.
Well, it's neither here nor there. It's that motion is not in front of me, not on the docket. So next time we appear, we can do that. So I'm going to.
Well, Judge, we filed that motion. Should be on the docket. Motion to suppress was filed back in February.
He renoticed it. March 16th.
Well, I'm just looking at my docket. I'm not doubting what you say, Mr. Carroll.
Judge, it's the worst search warrant I've ever seen, I think, in all my 40 years as far as the state.
Well, you know, Mr. Carroll, every time I practice with
Since
you,
the
I always
last
get
one.
the worst search warrant I've ever seen in 40 years.
It's since
30
the
40 years.
first one you've seen since the last one.
Since the last one, yeah.
Well, they keep getting worse, Judge.
Well, it could be.
There's absolutely no probable cause for their search.
Okay, well, we'll get to that. Miss,
I guess I need to clarify one thing. Is there a motion filed in 20 CR 76? Because I don't have that.
would you have the one filed in 47?
I do have that one.
I think
I don't have one filed in 76.
I think they're the result of the same search, Judge.
No, they're two separate incidents.
Judge, I'm looking on CourtNet. We haven't received either motions, and they're neither one showing up on CourtNet as being filed in either indictment.
Who did you send them to, Mr. Carroll? Who's your certificate to?
My certificate says they were sent to Jesse Stockton, Commonwealth Attorney.
Well, see, we'd have no way to get them then, would we, if they weren't sent to the clerk's office or the.
And to the Clinton Circuit Clerk.
Okay. The clerk's office want to check the file and see if they're there.
Jason Warner. No.
This is Jessica.
I believe it is. Did you do?
Is the clerk's office on the line?
Yeah. No, I'm talking about jail.
What's Mr. Denny in jail on right now?
He is in jail on the new charges that he's to be arraigned on today, which are theft-related charges.
I don't have a case that he's being arraigned on today.
No, that's incorrect. Those cases are going to the grand jury today, the two that are subject to this.
Was
bond
he in jail
revocation.
on the F case then? Is he in jail on an F case or are you doing a direct submission?
There's F cases now, whether no, these are both direct submissions. I apologize. These are both.
Okay, is the clerk's office on the line?
Yes, I am now.
Okay, could you tell us what this gentleman is jail, why he's in jail?
Okay. The sheriff informs me that Jason Warner on his case got a district court warrant. I wasn't aware of that.
So he's got an F case.
Yes. On one of the two cases that are going to the grand jury today.
Okay.
Yeah, it says that new charges was obtained April the 26th and April the 27th in district court.
Okay. Well, he's still, I can't set a bond on either one of those because that's an F case and there's no motion to reduce the bond or anything now.
He has bonds that he's posted in both cases in front of us, and I think Jesse's asking for those to be revoked.
Yeah. Yeah, I understand.
Looks like he's posted a
Even if I
$15,000.
What I'm saying though is even if I revoke those two bonds, he'll still be held on the F case bond that's not up yet.
Well, it'll be up today because you'll be setting new bonds when it.
Well, that's, yeah, but it's not right now yet. And the grand jury might not indict him. I don't know. You know,
I think I'll retire if that happens.
don't. Okay. In any event, I'm going to hold him. There just seems to be to revoke his bond to see what happens on these other cases here. I'll just be setting a new bond anyway if the indictments come in, Mr. D. So I'll review those so it doesn't, you know, I'll look at all of them at the same time. If Mr.
Okay.
You understand, Mr. Stockton understand, but I'm gonna.
Well, Your Honor, with all due respect to you and Mr. Carroll and Mr. Denny, this is probably the case that has caused me the most anguish over the last year.
Well, I just said I was revoking him on these two.
Okay, well, I just want to make sure
I'm
he's held.
revoking him on these two, and then when I get the other one, I'll take a look to see if the bond is sufficient that I've set on these two previously. Once I take a look at the indictments, that's what I'm saying. Okay. Okay. Well, thank y'all very much.
Thank you, Your Honor. Thanks, Jesse.
Thank you, Tom.
Okay. Now, I want to go. What private attorneys do we have on here now? Is anybody else on here?
Judge, can I be excused? I believe that's all I have.
Absolutely. Have a great day. Thank you, Mr.
Thank
Carroll. There's Mr. Coleman Hurt.
I'm not Coleman Hurt.
I see Coleman Hurt. I don't.
Okay. You wanted to go to Russell County, Your Honor. I've got a client in Russell County.
That's fine.
Okay, let me see how many cases Mr. Hurt has first. Mr. Hurt, how many cases do you have?
Judge, I just have one. It's
That's what I figured. What is it?
It's Commonwealth versus Christopher Burton. He's in the Russell County Detention Center. And I believe Mr. Stockton, I believe we're just looking at dates maybe on that, or that may be premature. I'm not sure.
Well, let's get Christopher Burton up here. Commonwealth versus Christopher Burton, 20 CR 0029. Are you Christopher Burton?
Yes.
We also have 20 CR 0031.
And Judge, there is a companion case for this one. I don't know if the court wants to take them up at the same time or not.
I got two.
Okay.
Who is the companion case?
I think is Joseph Edner, who is represented by Mr. Shefford.
Well, I'll just wait and take that one up when we get to it. Do y'all have an agreement on this?
No, Your Honor, this case was set for trial back in December. I think we had to continue it, and there's no resolution. We'll just have to have a trial whenever we can set a trial.
This is the one we had the hearing on, right? Then.
Yeah, and we took the victim's testimony, but
Yeah.
that was it.
Yeah.
Or by video, I mean.
Well, I have no feeling of certainty as to setting a date yet. I thought I would, but we'll continue this case until 10 June and to set a trial date. I guess we could set a trial date now and see if it happens. Which is your preference, Mr. Stockton?
The only issue I've got, Your Honor, is if set a trial date. If we don't set a trial date, I might not be able to set one very quickly because I have a DNA expert that have to.
Okay, I think that's a good point. Let's just go ahead and set one out.
Yeah.
I'll get the official laptop calendar out. How much advance notice do you have to schedule this person?
I would think if I had 45 days, 30 to 45 days, I could make sure they're available. They shouldn't be very busy court days right now.
Yeah, at least for a while, it'll be easier.
For a little while, yeah.
Um,
And if we schedule it and are able to have a trial before July, then I would be able to try Mr. Edner in front of a new jury after July.
well, let's go somewhere in June. You anticipate this to be a 1 or a 2 day?
I would think 1 day, but
Look at June the 15th.
that's fine with me, Your Honor.
I have court that day. It may be possible to get it moved. I'm not sure.
What do you
Judge,
have?
we're supposed to be setting them for 2 days because we have to set an entire day aside for void hour.
I'm going to do that. That's the reason I did it on. Hold on a second. That's the reason I had it on the 15th, so we could do the 15th and the 16th. What kind of court you got on the 15th?
I believe that's a juvenile docket day. Like I said, I may be able to get that moved.
Well, that's going to be on every Wednesday, though, isn't it? Is that every Wednesday? Juvenile docket?
Wednesdays and Thursdays are the worst days, but like I said, I can try to move those on.
Okay, let's set it on the 15th and 16th. Okay, we're on the 15th and 16th. And when we get the companion case here in a few minutes ago, are you going to try these individuals together, Mr. Stockton?
No, they have to be separated. There's Bruton issues.
Okay, that's what you alluded to that a few minutes ago with the new jury. So,
Yes.
okay, thank you very much.
Thank you, Judge. That's all I have.
Okay, now let's go back to Mr. Cross, who's been patiently waiting. What do you have, Mr. Cross?
Honor, I have two cases. I have Tommy Claiborne in Russell County.
Okay, let's do Tommy Claiborne, Thomas Claiborne first, then, if that's okay with you. Commonwealth versus
Froze on us.
Doctor's letter in there if it's in there.
You had it on your desk.
Maybe in his other file. He's got two files.
Judge, you've been frozen. You just now came back.
That's it.
Commonwealth of Kentucky versus Thomas Claiborne, 20 CR 0045. Are you Thomas Claiborne?
Yes, sir.
Okay, take your mask off there, if you will. Everybody can get away from you. Mr. Claiborne, born in 1974.
Yes, sir.
Last four digits of your social security number 0040.
Yes, sir.
Okay, I guess we're here today on a motion for shock probation. Is that correct, Mr. Cross?
That's correct, Your Honor.
You want to proceed?
I will, Your Honor. Your Honor, first of all, I want to say that I am Mr. Claiborne's attorney. I am not his doctor. I have, however, filed with the court and furnished to Mr. Stockton substantial medical records. Tommy's pretty sick. I don't think anybody ought to die in prison. I don't know.
Well, give me some factual situations other than dying and pretty sick. Tell me.
He's got liver disease, Your Honor.
Cirrhosis, cancer, what?
Yes, cirrhosis basically, and Tommy's got a long history of substance abuse, including alcohol, and we have filed the records with the court and the Commonwealth, and I know Mr. Stockton has spoken to the nurse practitioner that wrote the letter. I didn't write the letter for Mr. Claiborne, Your Honor. That letter came to me. I heard it was coming, and she sent me a letter. I sent it on.
Ms. Thompson, do we have a copy of the letter here in chambers?
Yes, it should be in your binder.
Okay, let me see. Okay. Okay, go ahead, Mr. Cross.
Your Honor, Mr. Claiborne isn't going to get much better. I don't know what his long-term prognosis, of course, is not good. I guess what I'm saying is I don't know how long-term is going to be. I've known Mr. Claiborne for many years, known his family. He's been self-destructive, Your Honor, basically. Mr. Claiborne's family is quite frankly a family that has a propensity for substance abuse. I've seen it with his uncles and other people. I would ask that the court release Mr. Claiborne, subject to whatever kind of restrictions and conditions are appropriate. He can afford home incarceration with a curfew. If he's out, if he violates it, so be it. But I just think that Mr. Claiborne would be an appropriate candidate for release in this manner.
Okay, the letter is dated 11/4. No, it's 4/12/21, April 12th, 21, and it's signed by nurse practitioner Dr. Karen Bennett Baker, who is the medical director of the Russell County Detention Center. And in the letter, she says that it is a burden upon the Russell County Detention Center because they do not have on-site coverage 24 hours a day. You have that letter in front of you, Mr. Stockton?
I do. I've read it and I've spoken with the lady.
Okay, what's your position on this?
Your Honor, the Commonwealth is opposed to shock probation at this time. Just to review, and then I'll get into the specifics on medical. Mr. Claiborne has a 10-year sentence on trafficking. He was to serve a split sentence and he was revoked on his probation. He was supposed to go to long-term rehab and he was faking doctor's appointments and he wouldn't go into the doctor and he was getting out of jail. And that's the reason he was revoked. Now, after reading this letter from Dr. Bennett Baker, I think she goes with Dr. Bennett after speaking with her, I was confused about some of it. So the second paragraph basically says that he has severe liver cirrhosis. And then she says he had a score of 11 out of 40. It's on a scale 6 to 40. And I asked her and she said, that's the least severe. The lower the number, the less severe it is. And it says estimates a 3-month mortality. And I thought, well, has he just got 3 months to live? And she says, no, he has a very low chance of passing away from this in the next 3 months is what he says. And she basically said that right now he's doing well. His situation's under control. Also, you go to the next paragraph, it talks about he has liver disease, but it's in the least severe stage. She did tell me, and it's indicated in her letter, that it would be better if Mr. Claiborne was in a jail where there is a 24-hour nursing facility, nurse on call, like Somerset or somewhere like that. But she says right now there's no need to move him. They've not applied to move him to anywhere. I spoke with John Grimes or James Grimes, the Class D coordinator at the Russell County Jail. He said that as of right now, there's no plans to move Mr. Claiborne. So I think that this is, and I even reached out to Mr. Claiborne's family and one of his family members, and they said they didn't want him to die in jail, and I don't want him to either. But as of right now, it doesn't look like Mr. Claiborne is dying in jail after speaking with the doctor now. She's available to testify after 11:15 today.
You were frozen there after you reached out to the family.
Oh yeah, I reached out to one of the family members that Mr. Cross had quoted to me, and they told me they didn't want Mr. Claiborne to die in jail. And I can understand that. That's the reason I called the doctor. And from talking to her, there's little chance of that happening in the near future. So from these diseases, I agree with Mr. Cross. He is sick, but he's not terminal at this stage. And his medical situation's under control. And Dr. Bennett's available to testify after 11:15 if we can get her on the phone if the court wants to hear from her. But that's based on my conversation with her.
Your Honor, I will only dissent from Mr. Stockton's statement a bit. Liver disease is generally terminal. It doesn't get any better. All they're doing now with Tommy is managing him. And it might be good to talk to the nurse practitioner. I'd like to get Tommy out. He's had a lot of struggles and not helped himself in many ways, but again, it's largely self-destructive what he's done, and it's taken its toll on him now.
I just say, Your Honor, again, the reason Mr. Claiborne's in jail is because of his own actions. He won't conform his conduct to obey the law or obey probation. And if he gets out, I have no confidence he's going to do it in the future.
Well, Mr. Stockton, I understand what you're saying, and I respect that. If he violates his conditions, we know where he'll be.
Well, I'm going to deny the motion for shock probation at this juncture. You can file another one if you have anything that goes beyond this letter, but this letter in toto does not justify it. I'm sorry that Mr. Claiborne is in the situation that he is, but the conduct and falsifying doctor's letters and doing all this sort of stuff and not taking advantage of the split situation. If it's, if the jail is on the line, I'm going to ask them to monitor his situation. And recently we had a prisoner from Russell County, I think it was let go by Russell County, picked up in Clinton County and ultimately taken to the state hospital up there. But it has to do with the severity of their conditions. And I don't think based upon the letter that we have, but that it would get there. So thank you very much. You have any other cases, Mr.
Yes, Your Honor. In regards to Claiborne, Your Honor, what I will do in order to preserve the court's right to review, I'll go ahead and refile a motion for shock and set it out, and that way we can review it with additional medicals, and the court won't lose jurisdiction of it.
Okay.
And I have one other case.
What's your next case?
Kevin Haddocks,
Okay, go ahead.
motion to revoke. Good morning, little man.
Good morning, Mr.
I'm well, who you
Cross.
talking to, Mr. Wait. That's not a good way to start this, Mr. Cross. Okay.
I've not had an opportunity to meet with Mr. Haddocks, Your Honor. I wanted to be sure he knew I was here.
Commonwealth Kentucky, Kevin Dale Haddocks, 15 CR 00101. Are you Kevin Hicks?
Yeah.
Yeah. And were you born in 1966?
Yeah.
Okay. We're ready to have a revocation cross up there. You see him on the screen, Mr. Haddocks? Wave, Mr. Cross.
Yeah.
Okay. Mr. Stockton, you want to proceed?
Yes, Your Honor, it's a motion to revoke. Mr. Haddocks has a 2-year sentence on theft by deception. He's already got about 257 days served on that. And he picked up a new DUI in Maribone, Cumberland County, Kentucky, along with a felony arrest on possession of Schedule 2 substance. And I have Deputy Watson available to testify, Lance Watson.
Your Honor, may I address the court?
Sure.
Your Honor, I've finally got up with Mr. Haddocks' family earlier in the week, and I spoke with Mr. Stockton at length about this case. I haven't got with Carson Payne yet. This is a situation where Kevo is supposed to be on Risperdal, I believe is the medication. According to his mother, he had quit taking it. I believe both Mr. Stockton and I thought there was supposed to be some sort of monitoring process that apparently didn't work. What I think would work best, Your Honor, is to pass this case where we can find out specifics from Mr. Payne and Mr. Haddocks' family. And to add to this, I really hate for Kevo to get revoked. His father, Walton, has got severe health problems, very serious. His prognosis is poor. Of course, that's what we live with. And I think if we could pass it today and let us try to sort this out, we may come up with an answer that's less than revocation if we can ensure a proper monitoring process.
Mr. Stockton?
If Mr. Cross needs 30 days to prepare on this, I don't care passing as long as he's in jail, but I don't know that my position will change. I know Mr. Haddocks has mental health issues. His mother goes to my church, but even if he's got mental health issues, he can't be out driving and speeding through Maribone and on oxycodone. So that's kind of where I'm at.
Mr. Payne, is he under a state PIN number?
He is not at this time, sir.
Can we get him on one if we're taking a look?
As long as one is ordered by the court pending revocation, I can. Yes, sir.
Well, that's what I want to do. Okay. We'll set him back up for June the 10th.
Thank you, Your Honor. I appreciate that. And I'll get with Mr. Payne next week, Your Honor. Thank you.
Okay.
Thank you.
That's all I have this afternoon, Your Honor.
Okay.
Thank you very much.
Okay. If the clerk's office will turn the camera off there in the courtroom, and we'll,
Thank you, Lance.
the deputy is excused.
Thank you, Judge. Thank you, Mr. Stockton.
Have a great day. Now, is there any other private attorney on here? We'll go back up.
Lee locked up.
Russell County Detention Center. Just bring them as you want them now, okay?
All righty, Your Honor. Your Honor, here's Mr. Jeffrey Clark.
Okay, that'll be fine. Commonwealth of Kentucky versus Jeffrey Clark, 18 CR 0076. Are you Jeffrey Clark? Okay. Were you born in 1988? You need to speak up a little bit. Okay. We're here on the day. Your attorney, Mr. Shuffett, is on the line. Can you see him?
Yes. Yes, sir.
Okay. Well, you want ahead and proceed, Mr. Stockton. This is a motion to revoke.
Yes, Your Honor. It's Mr. Clark has a 3-year sentence on flagrant non-support. He was terminated from drug court on October 12th, 2019. He's been an absconder ever since. And he last paid, I think, support 10/18/19 of 6438. There was, I think, on June 5th, 20, a $1,200 stimulus check or something was intercepted. So I believe that's what it was. So I think Mr. Shuffett said Mr. Clark was going to stipulate the revocation.
That's correct, Judge. We would stipulate that he was terminated from drug court, which was a condition of his probation.
Okay, I'll sign a revocation. Okay, next case.
Your Honor, we have Mr. Brown, Mr. Jesse Brown.
Okay. Commonwealth of Kentucky versus Jesse W. Brown, 21 CR 0005. Are you Jesse W. Brown?
Yes, sir.
Okay, we're here today for the purpose of arraignment. What's your year of birth, Mr. Brown?
25, 1989,
Last 4 digits of your social security number.
8111.
Okay, the grand jury of Clinton County has returned an indictment against you, charging you with murder, failure to wear seat belts, operating a motor vehicle under the influence, reckless driving, failure to maintain required insurance, leaving the scene of an accident, failure to render aid, speeding over 26 miles over, failure to use child restraints, wanton endangerment, three counts, persistent felony offender, 4 counts. Do you understand those charges?
Yes.
Mr. Shuffett, do you acknowledge the identity of your client, receipt of the indictment, waive formal reading and arraignment, and enter not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, I'm going to sign a reciprocal discovery order, Mr. Brown, in which the Commonwealth will give your attorney, under the terms of which the Commonwealth will give your attorney the evidence they have so that they will prepare for the case. Now, since this is a new indictment, I wouldn't think that there would probably be any need to have a June date on this. Do you have all the evidence, from the lab or anything? Is there any evidence to come in, Mr. Stockton?
Yes, there'll be lab reports that we've not received yet.
Okay, well, I guess then you can redocket this for June if you get those lab reports. And Mr. Shuffett, if you have been furnished some time to prepare for the June, we'll set it, but there's no reason to put it on the docket until then. Now, is there an issue of bond here, Mr. Shuffett?
Not at this time. We may be filing that in the future.
Okay. Your attorney has chosen to reserve. You have a right to bond reduction as a matter of right, Brown, and so your attorney for your protection has decided to reserve that. Is that correct, Mr. Shuffett?
Yes, Your Honor.
Okay, so you'll next appear when it's redocketed. Let me just out of a precaution, go ahead and docket it for July the 15th. Don't you think that'd be a good idea, gentlemen?
Yes, Judge.
July 15th. Okay, thank you very much.
We have Miss Allison Dean.
What's the last name again? What's your name, ma'am? Need to speak up. I can't hear what she's saying.
Dean. Allison Dean.
Okay. Something wrong with the microphone over there at the Russell County facility. Commonwealth of Kentucky versus Allison N. Dean, 21 CR 0008. Are you Allison Dean? Okay, Russell County, there's something wrong with your microphone there.
Sorry, that's me.
Okay. Miss Dean, were you born in 1993? Last four digits of your social security number 2005? Okay. We're here today on an arraignment. You have a right to remain silent, okay? Which, since I can't hear you on the microphone, is not that big a deal. But I would recommend that you take your attorney, Mr. Shuffett, is on the line. Wave your hand there, Mr. Shuffett, so she sees you.
Right here.
Okay, the grand jury of Clinton County has returned an indictment charging you with possession of controlled substance, first degree, possession of drug paraphernalia, wanton endangerment, 3 degrees, being a persistent felony, 3 counts, persistent felony offender, 3 counts. You understand those charges? Mr. Shuffett, do you acknowledge the identity of your client, your receipt of the indictment, formal reading and arraignment, enter a plea of not guilty, reserve all pretrial motions?
Yes, Judge.
Okay. Now, in this case here, what is, I guess, are there any chemical reports or anything that come in, Mr. Stockton?
No, Your Honor, I think we have everything. She's a state prisoner also, so if we can have a pretrial, maybe we can resolve everything next month.
Okay, well, let's set the next pretrial for June the 10th.
And Judge, I think there are 2 indictments. Is that correct?
Yes.
Yeah, the second indictment is 21 CR 0047, and that's for promoting contraband, first degree, being a persistent felony. You're correct. Do you acknowledge receipt of those indictments also?
Yes, Your Honor.
Okay, well, thank you for bringing that to my attention. It got folded over there. Okay, we'll see you, ma'am, on June the 10th.
Good up here, Joe. Your Honor, you have Joseph Edner.
Edner.
Your Honor, this is the companion case to Mr. Hurt's Burton case earlier.
Commonwealth of Kentucky versus Joseph D. Edner, 20 CR 0027. So Mr. Hurt is the conflict counsel. Is that correct?
Correct.
Okay. Mr. Edner, were you born in 1989?
Yes, sir.
Last 4 digits, social security number 4535.
Yes, sir.
Okay, now your co-defendant appeared earlier and a trial was set for him, I believe, June 14th and 15th. Was that what it was?
15th and 16th, Your Honor.
15th and 16th. Okay, so Mr. Stockton, you're here to set this on a trial. I would assume, Mr. Shuffett, you don't have an agreement. Is that correct?
Not at this time, Judge.
Okay, and then do you want to wait till after the trial is over, Mr. Stockton, to set this next one in case?
I would prefer just to go ahead and set it because this has been pending for a while, and that way I can get my expert witnesses lined up.
Okay. We can do that. I'm going to set it in August since I have no certainty as to how long it'll take us to seat this next jury, if you know what I mean.
Yeah.
I would think that the 17th and 18th of August.
That's fine with me, Your Honor.
That's fine, Judge. And can we set it for pretrial in July?
Well, wait just a second. I'm getting here. Seventeenth and 18th of August. Okay. Okay. Now, and you want a pretrial when?
July would be good, Judge, I think.
Okay. The pretrial then would be on July the 22nd.
It's the 15th, Judge.
Yeah, that's right. The 22nd is Monroe County, July 15th. Okay. Okay, thank you very much.
Your Honor, we have Mr. Donovan Waller.
Okay. Commonwealth versus Donovan Waller. 21 CR 0023. Are you Donovan Waller?
Yes, Your Honor.
Okay, we're here today on an arraignment. You have the right to remain silent except for identity questions. Were you born in 1974, Mr. Waller?
No, sir.
You weren't?
No, sir.
What's your year of birth?
1994.
Well, I guess you were born in 74. Then that added, you already get lost 20 years. We hadn't been here 5 minutes, you know. In 1994, the docket will be corrected. Last 4 digits of social security number of what?
3617.
Okay. You're here today for the purpose of arraignment. You have the right to remain silent. Anything that could be used against you. The grand jury of Clinton County has returned an indictment charging you with possession of controlled substance and trafficking controlled substance first degree. You understand those charges? You understand the charge? Okay. Mr. Shuffett, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay. I'm going to sign a reciprocal discovery order, Mr. Waller, that where the Commonwealth will give your attorney all the evidence that they have that's discoverable, and so they can prepare for your defense. What's the bond in this situation?
Judge, it's a $15,000 surety.
Okay. Has your client not been able to make a $15,000 surety?
Your Honor, he has not been able to make that. I've had a few conversations with him during that time. If the court would consider an unsecured bond, I think that might be at this point the only thing.
I'm not going to do an unsecured bond. A $15,000 bond is not a very high bond. Nobody has to come up with a dime, Mr. Waller. They just have to come up and guarantee that you'll be there. Do you have any family or anything in Clinton County?
No, sir.
Where are you from?
Elizabethtown.
Yeah. So you have nobody in Elizabethtown or anywhere that'll sign a bond for you to get you out?
No, sir.
What do you say, Mr. Stockton?
I think if he can't make the bond, we need to flesh this out at a hearing, because I'm concerned about him not having any ties down here. And if we do an unsecured bond, what about locating him and everything? That kind of concerns me.
Yeah, well, we can sit. Go ahead,
Judge,
Mr.
I think his plans are to remain in the Clinton and Cumberland County area. The clerk
course,
is doing a
you
fairly,
don't
a fairly good, they're scrutinizing these candidates for surety pretty closely. It's not just anybody that can walk in there and sign. I've had clients tell me they're being turned down.
Well, I've not been made aware of that. They know what to do. There's an affidavit there that people take seriously when they come in. They sign an affidavit to say that they're worth the amount of the bond, then they take the bond. I don't think any scrutiny beyond that is if somebody wants to subject themselves to perjury,
Maybe if Mr. Sheffield can get with me and we can go over the facts and what he's planning is, we might do an agreed order. And if we can't agree, then set a bond hearing. That's all I know.
Yeah, and we don't have to necessarily, Mr. Sheffield, wait till next month to do the bond hearing. After you negotiate with the Commonwealth, if y'all can't come to an agreement, I'll schedule one by Zoom so we can have a bond hearing before then. Okay.
Okay. Did we set this for June the 10th?
We did set it for June the 10th for pre-trial.
We'll tender an order if it's all right, correcting the typographical error in the indictment as far as the date of birth.
Okay, and we'll do a reciprocal discovery order as we said. Okay, well, thank you very much.
Your Honor, that's everyone we've been made aware of that you all may need that's housed here in Russell County.
Hey, Miss Megan, do we have anybody else in Russell County that's on the docket?
Checking.
Pardon?
I'm checking through my docket right now.
Okay.
No, that's all I have.
Thank you, Russell County Detention Center, for your cooperation. Okay. Maybe.
Thank you, Judge.
Okay, let's go to Charlotte Dawn Barnett. Commonwealth Kentucky versus Charlotte Dawn Barnett, 20 CR 00039. A motion for shock probation. Are you Charlotte Dawn Barnett?
Yes, sir.
You born in 1976?
Yes, sir.
Last four digits of your social security number, 5435.
Yes, sir.
Okay, Mr. Sheffield.
Your Honor, I had some discussions with Mr. Stockton about this. He proposed that we submit, and my idea to submit a drug court assessment order. It was his idea to set the case on the July docket, and it's his belief that he would, I believe, go along with her doing drug court, but wants to see her do a little time before she's released. Jesse, is that a fair
That's
statement?
correct, Your Honor. She has a 5-year sentence on promoting and 3-year on possession for a total of 5. She has 61 days jail credit, and I'll go into the specifics why I want her to July if the court wants me to, but I'll agree with Mr.
It's not necessary if y'all are in agreement on that. Sounds like, ma'am, that you're going to get a chance maybe to participate in drug court. That'd be a good thing for you and get you out of there. So make sure that you're an exemplary prisoner between now and then, and maybe this will work for you. Okay. Okay.
Mr. Sheffield, are you doing the referral?
I have it ready. I'll submit it after court.
Was it on June 10th is what you said?
July, the motion date.
It'd be July the 15th.
Okay.
July the 15th. Okay. Thank you. Thank you.
Thank you.
Next case, Commonwealth versus Luther Connor. Luther Connor. Commonwealth versus Luther Connor, 21 CR 0034. Are you Luther Connor?
Yes, sir.
Born in 2002.
Yes, sir.
Last four digits of your social security number, 0402.
Yes, sir.
You're here for the purpose of arraignment. You have the right to remain silent. Anything you say could be used against you. The grand jury of Clinton County has returned an indictment charging you with possession of controlled substance, first degree, and drug paraphernalia. Okay. Do you understand those charges?
Yes, sir.
Mr. Sheffield, do you acknowledge the identity of your client, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, what's the bond in this case?
It's a $15,000 surety.
Okay, how long have you been in jail, young man?
Well, he,
About a month,
Do what?
about 30 days, sir.
Okay, do you have anybody to make your bond?
Not a surety bond, no, sir. Not a 15,000 surety bond.
Well, I'm going to recommend that y'all do the same sort of consultation with each other, Mr. Shuffett and Mr. Stockton, on this case as we do.
I'm confused on this, Your Honor, and I don't mean to interrupt the court, but he's charged with possession. I thought he was administratively released from Class D possession.
He also has I don't know.
Yeah, and that is a presumptively probated case, and he did make a bond in district court. He made a $2,500 cash or 2 times property bond.
Pre-trial is on. What's the deal on this?
well, like I said, he wasn't eligible. Of course, in district court, he actually had to post a bond. He wasn't AR eligible. And then at the time when he was served with this, he had a new charges. You know, he was already in custody for a few days on a new charge before he was served with this, so he wasn't eligible. So,
Is it a felony charge, a new charge?
well, he's done pled guilty. It is a criminal mischief third. He pled guilty on April 13th. So,
Okay.
So is he a state prisoner now?
no,
No, as a misdemeanor.
Well, no, he would have to be a county prisoner.
he's not serving any time for anything.
So okay. So he's no longer, is he eligible now for an administrative release?
No, because you set a bond on him when they called you.
Okay. Well,
I'd say Mr. Sheff and I agree on that.
okay, well, y'all get together and they'll get back in contact. We'll set Mr. Connor on the June docket, June the 10th, and Mr. Connor, your attorney's going to talk to Commonwealth to see if can be some kind of bond agreement on you. Okay, till then, where are you going to live if you get out, Mr. Connor?
My grandma's house.
And what is her name?
Charlie can answer.
Okay. Okay, well, thank you very much. Josh Davis. Commonwealth versus Josh Davis, 21 CR 0040. Are you Josh?
Yes, sir.
You're here today for the purpose of arraignment. You have the right to remain silent, okay? Were you born in 1988, Mr. Davis?
Yes, sir.
Or the last 4 digits of your social security number?
7367.
Okay, the grand jury of Clinton County has returned an indictment charging with lawful taking parts from a motor vehicle, $500 or more, and being a persistent felony offender.
Yes, sir.
Okay, so where's that radio noise coming in from?
They just had opened the door from the.
Okay, so okay, you have the right to remain silent. Okay, and you've heard the charge. Mr. Shuffett, you acknowledge the identity of your client. Interplea not guilty, reserving all pretrial motions.
I do. I would note for the court that I think this is a direct presentment. I don't think this case came through district court, although I've represented Mr. Davis in the past. I don't think I've ever been appointed on this case.
Okay, I'll sign the appropriate order. Mr. Davis, I'm going to do reciprocal discovery order, which means the Commonwealth will give you the evidence they have in your case so you can prepare. What's the bond in this case?
15,000 surety.
Okay. How long have you been in jail, Mr. Davis?
30 days, sir.
You don't have anybody signed even a $15,000 surety bond for you?
No, sir. I had talked to my boss and everything, and he had spoken with y'all, and he said that you might give me an OR bond today, saying that I've been in here.
I don't know who your boss is.
The boss is the victim in this case, Eddie Dalton, Your Honor, and he's spoken to me wanting Mr. Davis out because he believes the other person is the main one. He wants Mr. Davis's cooperation in the case and also put him back to work. And so I just relaying that to the court.
What's your position on bond, Mr. Stockton?
Well, I don't think Mr. Davis is going to run off anywhere. I think I would ROR him on the condition he'd be on a curfew, work, home, church, no further violations of the law.
Well, if that's what the victim desires, is that what he told you?
Yes, Your Honor. He's been in a couple.
Well, that's what we'll do. And the conditions are, I want you to understand it, Mr. Davis, you're not supposed to be at work, church, or the doctor. Okay. You sign on your own recognizance and you'll be under that curfew. This does not involve drugs, it appears at this juncture. So I won't do any drug testing on it, but you're to be there at home. You understand?
Yes, sir. I'll be there. I'll work right there.
Mr. Robertson, is there any information you need from this individual?
No, Judge.
The clerk's office makes sure when these individuals that have, we are going to come to make bond today, make sure you get a good email address for them. Okay.
I will.
Okay. Thank you. We'll see.
Mr. Stockton.
June the 10th.
Okay.
Thank you, sir.
June the 10th. Okay.
What's the co-defendant's name on that case?
Manus. What is it? He's not before the court yet. He's not been served.
Okay.
Robert Manus.
Emanuel Fluter. Commonwealth Kentucky versus Emanuel Fluter. Are you Emanuel Fluter?
Yes, Your Honor.
Okay, this is 19 CR 0005 here for a pretrial conference. Now, I understand it's been reported to me that y'all had a mediation that was unsuccessful in this case. Is that correct?
That's correct.
Okay. Is it time to set the case for trial?
Well, Your Honor, I don't know if competency is an issue. I filed a motion for ComC. Unless they're willing to stipulate, we'll need to have a hearing on that. And then we'll be ready to set a trial date. I know they filed several pretrial motions. I think there's 6 motions that's been filed before the court.
Judge, I think in regards to competency, we've met with Mr. Fluter on basically a weekly basis. And I don't think we're concerned about that at this time. I know the last KCPC report found him competent. I think that procedurally we can stipulate to the report and the judge can make a finding based on that.
Yeah. Once that's done, then I'm ready to set it for trial, Your Honor.
How many days do you think it'll take to try this case?
I would at least set aside 3 days.
Are the results of the impasse, are they confidential or can you disclose them to the court? I'm not aware of that on these mediations. We've just had one other mediation.
I don't mind disclosing it if the defense doesn't.
Oh, I think that's fine.
Yes, I think that's fine, Judge.
Okay, well, where are we on this case?
Your Honor, the defense proposed doing a 30-year sentence on murder and 10 years on assault. And basically, I'm not willing to go less than 40 years on murder. And the reason is it makes a huge difference on his serve-out time because he's probably going to.
It's an 85%, right?
On the murder. And probably what's going to happen is while he's in prison on the murder, if you plead to a lesser charge, even if you stack it, he's going to get enough good time behavior and everything. It's going to flatten that out. So really the assault would be superfluous as far as any time served. So that's my position. And I'm a lonely committee of one in this case, and I'm not going to do that on this type of case.
What would a life sentence entail?
Well, it'd be either life or he'd be parole eligible after 20 years. And that's any case, any murder, he's going to be parole eligible after 20 years. So,
unless he pleads guilty to 40 years.
That's right. He's still going to be parole eligible at 20, but his serve out's going to be longer if he serves out.
I thought there was an 85% rule even on the 40 years.
No, I mean, if it's a serve out, he'll be 85%, but he could be paroled in 20 years, even if he gets life. More than likely, it won't happen. He could be paroled.
Was a life sentence discussed?
It was. It's rejected.
He could get in at trial.
That's the most he can get. I mean, there's no aggravating circumstances in this case.
Yeah, it's capital, but it can't be sentenced at that because we were reviewing, Miss Meg, my staff lawyer and I were reviewing that the murder statute, and it's interesting that it identifies all the murder as a capital offense, but then stipulates that the sentencing can't happen unless you have these aggravating circumstances. But it's still referred to as a capital offense. Is that the way y'all understand it?
Yeah, it needs some reform, in my opinion. But I'm not.
It does. Because, I mean, she brought it to Ms. Thompson's on the line, but she brought it to that it probably gets treated as a Class A as far as sentencing is concerned, unless you have the aggravating. It looks like to me it ought to be identified as that, but it's not. I kept on looking at the instructions back and forth, but I'm glad we read it right. She read it right, but in any event, you want to go ahead and set a date now?
That's
how many days do you think this will take?
I'm thinking at least 3. I don't know about them.
Well, I think with jury selection and any added time that COVID precautions would place on that, I think a full week we would need to set it for a week.
Well, I tell you what we can do. We can start it on a Monday, and then just not schedule anything the rest of the week and just do it from day to day as we need to do. I mean, in a case like this, I do not want a jury to go out over the weekend. You understand why? I don't know whether you know what you want. Now, will there be an issue as far as change of venue in this case?
We had filed some motions. We probably need to set a pre-trial in the future to review those motions as well. I know that we filed them right before COVID, and of course the chaos occurred with COVID.
Now we can go.
How about August 2nd?
Your Honor, I'm going to be out that part of that week.
Okay.
And I will be on vacation the week before, so I'd hate to start such a serious trial. Of course, being on vacation the week before, so I would be.
You can take your papers with you.
I would like to at least go into September if we could, because I've got subpoenas out of state I have to domesticate.
Okay, yeah, let's go into September then.
But the week of the 27th, I think. When is your Cumberland motion day?
Wait a second. I'm having trouble pulling this up. It would be the week of the 27th.
Which one of those weeks do you not have a motion day?
The 27th, the week of the 27th. We don't.
Okay.
We have open.
It's fine with me if you want to set it that week.
That works with my calendar, Your Honor.
Okay, now when do you want the pretrial set for? In July, maybe?
I think that would be appropriate, Your Honor.
Yeah, that way, if there's a venue change or anything, we can keep the same dates. Would be July the 15th would be the pretrial.
Okay, thank you, Your Honor.
Okay, thank y'all very much.
Judge, that is my only case. May I be dismissed, please?
Great day. Have a great day.
Thank you, Your Honor.
Commonwealth versus Brandon Hall. Commonwealth versus Brandon Levi Hall, 21 CR 00011 and 21 CR 00043. We're here today for the purpose of arraignment. Mr. Hall, you have the right to remain silent. Anything you say can be used against you. Mr. Hall, were you born in 1982?
Yes, sir.
Last four digits of your social security number are 377. Is that correct?
3773. Yes, sir.
Okay. The grand jury of Clinton County has returned an indictment charging you with possession of controlled substance first degree, wanton endangerment first degree, wanton endangerment first degree, wanton endangerment first degree, and wanton endangerment first degree. There are 5 counts of wanton endangerment. You understand those charges?
Yes, sir.
Mr. Shufford, this is your client here?
I have been appointed and represent him on the case that turned into 21 CR 11. The wanton endangerment cases are direct presentments.
Okay, I actually misstated. There are 4 counts of wanton endangerment and 1 case of possession and control of substances, which is the 11 case. I'm going to go ahead and point you to the subsequent case since the same qualifications are there. You can check to see if there's any conflict or anything after you have a chance to look at
There, I can tell the court based on the names on the indictment, there will be a conflict.
I thought as much. So, but I'll just, for the purpose of arraignment, you'll stand in today and then
that's
notify. You can notify us if there need to be conflict counsel and proceed on that. Okay. The grand jury of Clinton County has returned these indictments. You heard the indictments. You understand the charges, correct?
Yes, sir.
Okay. For the purpose of arraignment only, Mr. Shufford, do you acknowledge the receipt of the indictments, waive formal reading of arraignment, enter plea of not guilty, reserve all pretrial motions?
Yes, Your Honor.
Okay. We'll set this for a pretrial on June the 10th. What's the bond situation here?
Your Honor, before we address the bond, I'd like to make the court aware that Mr. Hall also has a Cumberland Circuit Court case, 21 CR 26, possession of a controlled substance, first degree, tampering with physical evidence, and PFO. I thought since Mr. Shovett had a conflict, I thought about asking the court to transfer the Cumberland County case to Clinton County, but it might be better just to transfer the 2 Clinton County cases to Cumberland County. That way they could all be addressed in one court, one attorney you could have. Because he has, I'd say you'll have a public defender in Cumberland.
How do you feel about that, Mr. Shufford?
Well, that might work.
Well, let me tell you what, let me let you review it a little bit, Mr. Shufford, and then you can get over with Mr. Stockton, maybe do by agreed order. You understand what they're talking about, Mr. Hall, is they might transfer your cases to Cumberland County so you get all of them at one place, so you can deal with all of them at once, what they're talking about.
Yes, sir.
If they come to that agreement, would you have any objection to that?
No, that'd be fine with me, sir.
Okay, so with that sort of direction, Mr. Shuffett, you can contact Mr. Stockton and y'all can proceed on it. If you do agree on it, include in the date, the June court date for Cumberland County, which would be June. We can actually do it on May the 27th. If you can agree upon transferring them to Cumberland County, and we can get the case moving a little bit, okay? Okay, well, thank y'all very much. Commonwealth versus Charles Hicks. Commonwealth versus Charles J. Hicks. Are you Charles J. Hicks?
Yes, sir.
Okay, were you born in 1980?
Sir.
Last four digits, social security number 9917.
Yes, ma'am. Yes, sir.
Okay, this is 20 CR 0013. You're here today for the arraignment. You have the right to remain silent. Anything you say could be used against you. Do you understand that?
Yes, sir.
Grand jury of Clinton County has returned an indictment charging you with drug paraphernalia, possession of controlled substance, and trafficking controlled substance, first degree. You understand those charges?
Actually, no, sir, I don't. I don't want those.
Well, wait. Just say no.
Yes, sir.
The first charge is possession of drug paraphernalia. Do you know what possession of drug paraphernalia?
Yes, sir.
The next one is possession of controlled substance, first degree, first offense, methamphetamine. Do you know what methamphetamine?
Yes, sir.
Okay, and the next one is trafficking of controlled substance, first offense, methamphetamine. You know what trafficking is, and you know what methamphetamine is.
Yes.
So you understand the charges. I'm not asking you if you have anything to do with this or you've done anything.
Yes, sir.
So now, Mr. Shuffett, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions.
Your Honor, I would do that. I do think this is a direct presentment. I don't believe this case came through district court.
Okay, we'll do an appointment for you, okay? Now, what's the bond on Mr. Hicks?
It's a $15,000 surety.
Okay, now, Mr. Hicks, for the purpose of this arraignment, I've appointed the Office of Advocacy. But you'll have to fill out a form to have their permanent appointment. Do you understand that? Do you own any property?
No, I just rent.
Okay. Do you have a vehicle or any money or anything to pay an attorney?
No, sir, I do not.
Okay, well, we'll get a form filled out on you. And Mr. Shuffett, you can probably go ahead and act upon this like it's going to be a full-time appointment, okay?
Yes, sir.
Just said, okay. The bond is $15,000 surety. Have you had anybody that's attempted to make a bond for you, Mr. Hicks?
Yeah, they have, but it wasn't approved. They weren't approved by Jake Stamey.
Yeah, who was the person?
They've been several. Robert Covey's tried to make it. Brandon Ferguson's tried to make it. I think Sheila Birch has tried to make it. I haven't really got to. I've been locked up. I haven't really got a chance to talk to anybody.
Yeah. Ms. Thrasher, are you on the line for the clerk's office now?
Yes.
Who has tried to make the bond here? What's the circumstance?
That I don't know. I can get Jake if you need it real quick.
Well, just check on that. You don't need to bring it over in front of the court. And we'll let Mr. Shuffett, you and Mr. Stockton consult on this bond, okay?
Okay.
We'll set this case up to come again on June the 10th. Commonwealth versus Walter Miller. Commonwealth versus Walter Miller. Commonwealth versus Walter Miller, 21/9. Are you Walter Miller?
Yes.
What is your year of birth, Mr. Miller?
8/27/84.
Last four digits of your social security number.
7915.
Okay, you have the right to remain silent as I read the charges against you. The grand jury of Clinton County has charged you with resisting arrest, fleeing or evading police officers in the first degree, reckless driving, operating a motor vehicle under the influence, operating suspended revoke, operating without a ignition interlock device, being a persistent felony offender. Do you understand those charges?
Yes.
Okay, you have a private attorney?
No, Judge, this is my case, unless he's hired someone.
Okay, so this came up from district court?
Yes.
Okay, so FK, so I'll continue that appointment. Mr. Shuffett, do you acknowledge the identity of your client, waive formal reading and arraignment, acknowledge receipt of the indictment, enter plea, reserving all pretrial motions?
Yes, Your Honor.
Okay, we'll set this case for June the 10th.
What is Mr. Miller's bond?
20,000 surety.
What other conditions are on that? I want an ankle bracelet on it. What else?
Just your standard 24-hour curfew conditions.
Okay, put an ankle bracelet on it too. Okay.
And no driving.
No driving and an ankle bracelet.
All right.
Okay. Taylor Phillips.
I didn't understand that. He was.
Go ahead, Mr. Miller. What did you say?
I called Brad or my law attorney, and he was supposed to ask if I can make a cash bond quicker than I can a $20,000 surety if I can do $1,000 cash and alcohol monitor.
No, I'm not going to allow you out on $1,000. You know,
right.
you know, that's the bond that I give you, and you're going to be on a curfew and an ankle bracelet and have somebody make that bond.
All right. Thank you.
Now, let me tell you something, Mr. Miller, come back here.
Yes, sir.
You know, if you make a bond and you get out and violate this next bond, it's going to be a bad thing. You understand what I'm saying?
Yes, sir.
Okay, thank you. Taylor Phillips. Taylor Phillips. Commonwealth versus Taylor Phillips, 21 CR 0042. Are you Taylor J. Phillips?
Yes.
What is your year of birth?
9/17/97.
Last four digits of your social security number.
5260.
Okay, you have a right to remain silent while we read the indictment. The grand jury of Clinton County has returned an indictment charging you with theft by taking over $300 and receiving stolen property. Do you understand those charges?
Yes.
Okay. Mr. Shuffett, is this one of your cases? Was this an F case or a direct submission?
Yes, this is a case that came up from district court.
Continue the appointment. What is the bond on this?
Bond on this one was 10,000 cash for twice property with a 24-hour curfew.
Okay. The case will next be heard on
Hurt somebody. Grab somebody else come in.
June the 10th.
And what are her risk ratings?
Moderate on both.
Miss Phillips, is there anybody who can sign a surety bond for you?
I'm sure they would.
Mr. Robertson, what was her bond again?
10,000 cash for twice property.
And what did you say her score was? I don't have that in front of me.
Moderate on both.
Moderate is what you're saying?
Yes, on both assessments.
Okay. Does she have FTAs?
Just one.
What are her other factors that get her to be moderate?
Well, she had a pending case in Wayne County. She has a prior misdemeanor and the one FTA.
Okay. Well, y'all can, Mr. Sheffield, you and Mr. Stockton can negotiate this and see, review the situation, Mr. Stockton, okay? Okay,
Okay.
June the 10th. Durwood Eugene Salisbury III. Are you Durwood Eugene Salisbury III?
Yes, sir.
Okay, were you born in 1979?
Yes, sir.
Last four digits of your social security number, 6680.
Yes, sir.
We're here for a pretrial conference. Have y'all reached an accord on this case?
No, not that. I know.
Mr. Stockton, your microphone's not on.
Your Honor, we had 2 cases to go to the grand jury last month, and the officer couldn't be there. They're being presented this month. So he'll have a total of 3 cases we should be able to set for arraignment and pretrial next month.
Okay. So let's continue the case to June the 10th then.
We expect those to be indicted today. Jesse.
Yes. Yeah, I have another officer presenting the cases today, so we can get them done.
Okay. It'll be fine. Thank you, Mr. Commonwealth of Kentucky versus Lloyd E. Smith. Are you Lloyd E. Smith?
Yes, sir.
Okay, were you born in 1951? Last 4 digits, your social security number 207.
Yeah,
Yeah. You're here for purpose of arraignment. You have the right to remain silent. Mr. Smith, the injury of Clinton County has returned an indictment charging you with trafficking and controlled substance, first degree, second offense, methamphetamine, possession of marijuana, possession of coke, first degree, first offense, methamphetamine, and being guilty of a persistent felony offender charge. You understand those charges? Mr. Sheffield, this is your client?
Your Honor, there should be 2 other arraignments also. I think there's a total of 3.
Yeah, here's another one, 0045, with traffic and controlled substance, first degree, second offense, FO, and 0046, traffic and controlled substance, first offense, second offense, or more, and a PFO.
Judge, it's my understanding that the indictment in 21 CR 35 was a charge that came up through district court, and the other 2 indictments were direct presentments.
Did you represent him in district court?
Yes, sir.
I'll appoint you on all the cases, on all 3 indictment numbers, and some conjunction, probably some merger in them anyway. Okay, what is this gentleman's bond?
10,000 cash, twice property with a 24-hour curfew with your standard conditions.
Okay.
Your Honor, I spoke with Lloyd earlier in the week, and he if the court were willing to do a twice property bond, he believes he can make that, and he believes he could make say a 50,000 10% bond as well.
Mr. Stockton?
Your Honor, Mr. Smith not only has these 3 pending cases, he's on parole. And with his propensity to commit crimes, I think the bond's very reasonable. I would ask for a hearing if we have to move to lower the bond.
Okay. Well, you can schedule a hearing if you want to, Mr. Sheffield.
Okay.
And I will tell you that in addition to the terms that they're there, if we open this bond up, as a matter of fact, I want an ankle bracelet on this thing. Because I'm very familiar with Mr. Smith. He's a frequent customer here, and it appears to me that I don't know if he's guilty of these charges, but there continues to be a long time, Mr. Stockton. So,
Yeah, I agree.
okay, thank you very much, Eric Stamey. Eric Stamey. Eric Stamey, is that how you say your name?
Yes, sir.
Okay. Commonwealth of Kentucky versus Eric Stamey, 20 CR 0060. Mr. Stamey, you were born in 1990.
Yes, sir.
Last four digits of your social security number 2530.
Yes, sir.
You're here today on a revocation hearing. What does the Commonwealth have?
Your Honor, Mr. Stamey has a 3-year sentence on possession of controlled substance, first degree. He had some problems reporting to probation. I've talked to Mr. Payne, and if Mr. Stamey will accept, we'd like to refer him to drug court.
Mr. Sheffield, have you talked to your client about that?
Yes, we've talked about that and we have no objection.
And we can set him June the 10th, Your Honor, for review.
Okay, we'll set the case on June the 10th. We'll do a review. They'll interview you to see if you're going to be in drug court. You understand what drug court is, Mr. Stamey?
Yes, sir.
Okay, well, if you get involved in that, you'll have an opportunity to turn your life around if you take advantage of it, okay?
I'll submit the assessment order after court.
Okay, I'll sign it. Next case, Commonwealth versus Jennifer Stockton.
That one with the notice of intent forfeiture on hers.
Commonwealth versus Jennifer L. Stockton, 21 CR 0044. Are you Jennifer L. Stockton?
Yes, sir.
Were you born in 1996?
76, yes, sir.
1976. Okay, 76. That is. What are the last four digits of your social security number?
5538.
Okay, you're here today for the purpose of arraignment. You have the right to remain silent. Mr. Sheffield, is this your case?
Yes, I believe if I'm looking at it right, I had 21 CR 12. And then the other one that you mentioned is a direct presentment.
I only have one here on her right now, which is 44. I might have mentioned some other ones.
No, there's 3 cases on the docket.
I don't see them. I might have. Oh, yeah, it had Jennifer Lynn on the next one. The first one had Jennifer L. Okay. That is 00110. And then the last one is 0012. Is that correct, Ms. Thompson?
Yes, one's an older case and
Yeah.
2 are.
Yeah, there's 18 CR case, and then that's 110, and then 210012, and we're here on 21 CR 00044 for the purpose of arraignment. You have the right to remain silent, Ms. Stockton. The grand jury of Clinton County has returned an indictment charging you with trafficking controlled substance, second offense, second degree first offense, trafficking controlled substance, second degree first offense, trafficking in controlled substance, third degree first offense, trafficking in controlled substance, third degree first offense, trafficking legend drug first offense, possession of drug paraphernalia, possession of marijuana, trafficking in controlled substance, first degree first offense, trafficking in controlled substance, first degree first offense, trafficking in controlled substance, first degree first offense, engaging in organized crime, being a persistent felony offender, 6 charges of that, it appears. You understand those charges?
Yes, sir.
Okay, Mr. Sheffield, do you acknowledge the identity of your client, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
It would appear to me, since this is a new charge, you're going to need some time. So we to prepare for this. So we'll set this on June 10th. All 3 indictment case numbers on June the 10th.
Well, just so I'm clear about the case numbers, I've got
Let me
CR
go
12.
Let me go over them with you again. This new one here was.
There's 2 new ones, Judge.
Okay, well, one of the new ones is 21 CR 0044. That's one of them, okay? The next case I have here is 18 CR 00110.
Yeah, and that's a motion by the Commonwealth, Your Honor.
That's a motion to seek forfeiture.
Okay. Judge,
Then we have-
what are her
wait just-
bonds?
Wait just a second. Then we have 21 CR 0012, which is another one for new arraignments that I didn't read. Is that right, Ms. Megan?
Yes, that's correct.
Okay, so this one would be possession, controlled substance, drug paraphernalia, traffic control, substance, possession of marijuana, and another PFO. I think that carries.
Oh,
So Brad, that gets you 21 CR 0012 is your other case you picked up, correct?
I believe that's right, Judge. What's the bond on the 2 pending indictments?
Looks like it's 10,000 cash or twice property on each.
Is that, are they essentially concurrent with each other or consecutive?
Well, it's 2 separate bonds.
Okay, so total would be 20,000 or twice property?
That's right. You have anything else in the line on this, in the pipeline?
no, this should be all of her cases, Your Honor.
Okay. Well, I'll let the two of y'all negotiate if you want to, if you can reach any about a bond change. I'm very concerned about the repetitious charges with these traffic possessions and PFOs and everything concern me. So if y'all want,
I'm not going to agree to a bond change, Your Honor, based on the testimony you heard from Sheriff Vincent this morning on one of the cases.
Yeah.
And Judge, just to clarify, I just pulled up the bond decision, and that bond was to stand for both indictments. It was noted on the bond decision.
Well, I want to, if that's the case, I want to put an ankle bracelet on it too.
That may be true. It's nothing in our system that says that, so.
Do what?
I said, nothing in our system says it covers both. I said, that may be true, but it's just nothing listed on our system. that says
Okay,
that.
well, it can cover both. Put an ankle bracelet on it. Okay, thank you.
Your Honor, another matter on her case. On
What?
18 CR 110, the Commonwealth filed a notice of intent to seek forfeiture. If there's opposition, I'll pass it. If there's not, I can enter an order.
Forfeiture of what?
Sheriff Vincent, when he took office in this older case, found $520 in cash that was never dealt with in that case. And if there's opposition, I'll just schedule it for another hearing when he's available. He's at the grand jury right now.
I have no, you can donate it to whoever.
Okay, well, I'll tender an order then.
Okay, thank you. Okay, the next case is Commonwealth versus Trenton Tucker.
And he has an arraignment and a pretrial.
Okay. Commonwealth, Kentucky versus Trenton Tucker, 21 CR 0007. Are you Trenton Tucker?
Yes, sir.
Okay, we also have 20 CR 0030, which is a trial conference, but I'll do the arraignment first. You have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you with assault, third-degree police officer, inciting a riot, disorderly conduct, and criminal mischief, second degree. You understand those charges?
Sir.
Okay. Mr. Sheffield, do you acknowledge that the client received the indictment, waive formal reading and plead not guilty, reserving all pretrial motions?
Yes, Your Honor.
The other case involves operating suspended, fleeing, driving, disregarding stop sign, being a PFO. Now, since this is a new charge, I would suggest that we take it out to June the 10th.
Judge, I think we're ready. I think we've tendered a plea to the court.
All right, Mr. Stockton, is your microphone's not on.
Yeah, we have an agreement on a felony plea, Your Honor, to resolve both cases if the court wishes to see that.
Okay. A motion has been tendered that says you wish to enter a plea. Is that correct?
Yes, sir.
Okay. Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
State your full name.
Trenton Dakota Tucker.
Carson, your microphone is on. Will you turn your microphone off? And Melissa, your microphone. Melissa?
Yes, sir.
Your microphone is on. You have another phone on, you're up on the screen.
Yeah, I'm logged in two different computers.
Okay, if you'll turn them off, thank you. Are you the same person named in an indictment? Hold on a second. Indictment 21 CR 007 and 20 CR 0030. Are you the same person?
Yes, sir.
Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney?
Yes.
Are you satisfied with his advice?
Yes.
Have you had plenty of time to look at evidence that the Commonwealth has against you and feel like you fully informed, that you're fully informed about the case and that you have enough understanding to enter this plea?
Yes.
Okay, you have the right, you have certain rights under the Kentucky and United States Constitution. I know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. Do you understand those constitutional rights?
Yes.
And by entering a guilty plea today, you give up those rights. I may consider the Commonwealth's recommendation range of sentence that is allowed by law. I do not have to accept any recommendation. Will this be a felony plea, Mr. Stockton?
Yes, Your Honor.
Okay, prior to accepting the recommendation, I will await a pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to you have the right to withdraw your plea, plead guilty if you don't want to accept the harsher penalty. You understand that?
Yes.
Okay, Mr. Stockton, will you proceed with the Commonwealth's recommendation?
Yes, Your Honor. In 21 CR 7, the defendant will plead guilty to assault third degree. He'll receive a sentence of 5 years. In 20 CR 30, he will plead guilty to fleeing and evading police first degree. He will receive a sentence of 5 years. The remaining charges in both cases will be dismissed. Those 2 5-year sentences will run concurrently for a total of 5 years. The Commonwealth will oppose probation. He'll pay court costs at the discretion of the court.
Is there any restitution that's owed here? No.
No, Your Honor.
Now, sir, is that your understanding of the plea agreement?
Yes, sir.
Has anybody, including your attorney, offered you anything, a recommendation, or threatened you in any way?
No.
You're pleading guilty because you are guilty?
Yes, sir.
Okay. Knowing your constitutional rights that I've explained to you, is it still your desire to give up those rights by entering this guilty plea today and allow the court to fix punishment within the range of sentence permitted by law?
Yes.
Okay. You understand that by entering a guilty plea to any, in this case, any future convictions could be enhanced under the persistent felony offender law and extend the range of your penalty under those charges. You understand that?
Yes.
Mr. Stockton, Mr. Sheffett, do you have a copy of that agreement with you?
Yes, I have it.
Hold it up to your screen.
Well, I'd have to, I don't have a physical copy. I have an email copy of it. They should have a copy of it at the jail. A physical copy.
Here it is, Judge.
Is that your signature on there, sir?
Yes, sir.
Okay, it should be dated today. Okay, so y'all make sure you date it today. Today, the day you signed it?
Yes, sir.
Okay, well, I'll accept the agreement, order pre-sentence investigation report done by probation parole, and set your sentencing for June the 10th. What is the next case on the docket, Commonwealth versus John Earl Ray?
Yes.
Okay. Commonwealth, Kentucky versus John Earl Ray. Are you John Earl Ray? Okay. We're here today for a competency hearing. Is that correct, Mr. Stockton?
No, Your Honor. We have a plea worked out. I believe they were going to stipulate competency.
That's correct, Judge.
Okay, this is 20 CR 0017, 20 CR 068, and 20 CR 0091. Is that correct, Ms. Megan? Are those the three indictments we're operating under?
Oh, yes, yes. They have two of them on the docket twice.
Okay, that'll be fine. Sir, I understand that you have tendered a motion that says you want to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea agreement freely and voluntarily given?
Yes.
Are you the same person named in these indictments?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney, and are you satisfied with his advice?
Yes, I have.
Have you reviewed the evidence the Commonwealth has against you, and do you believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a guilty plea, I need to know that you fully understand those rights.
Yes.
Not to testify against yourself, no one can make you say anything. You have a right to speed trial, but jury, the right to be represented by counsel at your jury trial. The right to examine all witnesses called to testify against you. The right to evidence, the right to call witnesses in your favor and have process issues compel their attendance. It's still this matter to higher court if you lose and to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of each charge against you. You understand that?
Yes, I do.
During a guilty plea today, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply the range of sentence provided by law. I do not have to accept their recommendation. Prior to accepting any recommendation, I will look at the pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you will have the right, however, to withdraw your plea of guilty and proceed to trial. Do you understand all those rights?
Yes, I do.
Okay, now, Mr. Stockton, what is the recommendation of the Commonwealth?
Your Honor, in 20 CR 68, the defendant will plead guilty to promoting contraband. First two counts, receive a total of 5 years on each case, run concurrently for 5 years. In 20 CR 17, he will receive 3 years on possession of a controlled substance and 5 years on assault third degree, 2 counts, each to run concurrently for a total of 5 years. The 5-year sentence in 20 CR 17 will run concurrently with those other 5-year sentence, but will be consecutive to the 3-year sentence on the possession for a total of 8 years, probated for 5 years supervised. The defendant shall receive credit for time served. He'll be evaluated by Adonta for mental health and shall follow any and all recommendations. He'll remain in custody until the evaluation has been completed by Adonta until final sentencing, whichever comes later. The Clinton County Jail shall transport him to Adonta if necessary. The Commonwealth agrees to dismiss 20 CR 91 in its entirety without prejudice. And the grounds for that dismissal, Your Honor, I've conferred with the sheriff, is the Commonwealth has evidentiary issues due to the victim not wanting to cooperate in this case. So we're agreeing to dismiss it without prejudice. He'll pay costs at the discretion of the court and be under the normal conditions of probation parole, and any contraband in this case will be destroyed.
Yeah. While I'm thinking about it, the circuit clerk's office need to bring the other plea we took, just need to go ahead and add the cost into the judgment. Okay, one cost. Was there a DUI in that other?
I don't think so, Your Honor.
I don't think there
Yeah,
was.
public intoxication, but no DUI.
Okay, it was, I knew it was an alcohol related thing. Okay.
Yeah.
Did you just understand what the Commonwealth said as far as the recommendation, sir?
Yes, I do.
Is that what you agreed to?
Yes, I did.
Nobody's threatened or coerced you. You plead guilty because you are guilty. Is that correct?
Yes.
Knowing your constitutional rights, is it still your desire to give up those rights? Enter this plea to the charges. Allow the court to fix your punishment in the range permitted by law.
Yes.
You understand by entering these pleas that any future convictions that you might have of felonies could be enhanced as far as the range of penalties under the persistent felony offender law. You understand that?
Yes, I do.
You have a copy of his plea so we can put his signature up on, they identify the signature. Is that your signature on there, sir?
Yes, it is.
Okay, well, I'll accept the agreement, order a pre-sentence investigation report, and schedule a hearing on June 10th. Now, if we can get the evaluation done, Mr. Sheffett, you need to kind of continue to get on that evaluation because it says the latter of the 2 days, right? So if he gets the evaluation done and gets it over to Mr. Thomas, he might be able to begin his probationary period on June the 10th.
Your Honor, for his benefit also, this was a complicated plea, and I think the court was on to something. I think it should also be in there that he'll see the SSC since he had the public intoxication.
Yeah. Okay. What are the court costs in the case?
$155.
Okay, you need some time to pay that, sir?
Yes, I do.
Okay, I'll let you have it 30 days, $30 a month, starting 1 month after you get released, okay?
Okay, thank you.
Okay, no problem. Okay, is there any other matter to come before the Clinton Circuit Court Criminal Division?
Oh, Your Honor.
Okay, then we shall stand in recess until the